Hello and welcome to Courts Today by LiveLaw. Let us start with today's top headlines. Saying that the evidence in the case was fictitious, a Rajasthan court has acquitted the suspended judicial officer and his clerks in a minor boy's sexual assault case. The Gujarat High Court has issued notice on a father's plea alleging illegal detention of his daughter by persons living in ISCKON temple. The Allahabad High Court has ruled that Prima Facie State Human Rights Commission has no jurisdiction to deal with custody issues. Madras High Court has granted interim bail to temple activist and asked him to refrain from making objectionable comments against women. And the Delhi High Court has said that friendly consultation is necessary before issuing Section 21 notice under the Arbitration and Conciliation Act. I am your host Urvashi with your daily roundup of legal updates from across the country. Before we move ahead, let me tell you LiveLaw Academy is offering a value-packed opportunity for the aspiring judges. This is the Judicial Service Examinations Preparation course. This comprehensive online course is designed to help you prepare for your judiciary exams. Classes are conducted by expert faculty, including retired judges. You would learn from actual case studies and other easy-to-follow study materials, and all of this comes at a very affordable price. If you are gearing up for the judiciary exams, this is a must-check opportunity for you. Enroll today and get 25% scholarship. You can check all details at www.livelawacademy.com, and we have mentioned the link in the description also. A special POCSO court in Rajasthan's Bharatpur district has acquitted a suspended judicial officer and his two clerks in connection with the case lodged against them. The allegations were of repeatedly sodomizing and sexually assaulting a minor boy and also threatening his family members of implicating them in false cases. According to the prosecution, the judge had been molesting the child for 1.5 months by intimidating him. And when this whole matter came to light in October 2021, the mother decided to go to the police and lodge an FIR in this case. In the FIR, she claimed that the judge met her son at a tennis court and after befriending him, would lure him to his house. There, the judge allegedly mixed intoxicants into alcohol or juice, and when the son became inconscious, the judge would sodomize him. His clerks were accused of committing the same acts. But the court has acquitted him and took into account discrepancies in the victim's and his mother's testimonies regarding the dates and times of the alleged act of sodomy and the fact that the mother, who is the complainant here, had denied the fact regarding witnessing the alleged act from her own eyes. The court categorically factored in the delay in filing the FIR despite containing serious allegations and the fictitious nature of the evidence produced by the prosecution in the case, making the case untrustworthy. The court noted that it was unlikely that the child would return home after drinking alcohol without their family members noticing. The court also considered that during her cross-examination, the complainant mother contradicted her previous statements, denying having witnessed the accused judge sodomizing the victim either at his residence or elsewhere. In its judgment, the court has also referred to other loopholes in the prosecution's case, like the medical witnesses denied injuries on the internal and external genitals of the victim child and the fact of recent rape. The victim stated that the accused judge made him drink alcohol, while the victim's brother denied in his statement that the victim came home inebriated. Also, majority of the witnesses have been declared hostile. The court thus concluded that the prosecution had not been able to prove the case. Regarding the compensation to the victim child, the court noted that since the testimony of the child victim had not been found credible due to its artificial nature, it does not seem to be justifiable to provide any form of compensation to the victim child. The Gujarat High Court has issued notice to the state on a habeas corpus petition moved by a man claiming that his daughter has been illegally detained by certain persons who used to allegedly live at Allahabad's ISCKON temple. The plea claims that his daughter left on 27th June with 23 tola gold ornaments and 3,62,000 cash from her father's residence. The family searched for her in the neighboring houses but did not receive any clear or satisfactory information. Later, they found out that the respondent, along with 7 other individuals associated with the Sevadan Shram at the world-famous ISKCON temple on SG Highway, Ahmedabad, had taken her away. The father told the court that 5 to 6 months have already passed. However, he is not able to get any information about the life of the corpus, and the police had not taken any appropriate action to find his daughter. A division bench of Justice Sangeeta K. Vishayan and Justice Sanjeev J. Thakkar has issued notice and the matter is now listed on 9th January. Stay tuned. Next, let me tell you, the Allahabad High Court has observed that in a prima facie view, the jurisdiction of State Human Rights Commission does not extend to dealing with child custody matters. In this case, last month, a woman, mother of 2 minor children, died under mysterious circumstances. Her parents filed a criminal case against her husband, who is currently in jail. An application was also submitted to the UP DGP, claiming that the 2 minor children were essential witnesses in the ongoing criminal case. However, their whereabouts were unknown. Concerns were raised about their safety, requesting the DGP to locate the children and hand them over to the parents of the deceased mother. Since a copy of this application was also sent to the chairman of the State Human Rights Commission, the commission took cognizance of the matter. It issued an order requiring the investigating officer to submit a report regarding the children's welfare. In response, the IO submitted a report stating that the 2 children were in the custody of an advocate and one of the relatives of the husband. Further, the commission asked for the children to be produced before it. It also asked the relatives of the husband who had the custody to appear before it. But they did not appear, citing ill health. Now the relatives have moved the High Court, challenging the order of the commission. They argue that the custody of the minor children is not an issue which can be gone into or adjudicated by the Human Rights Commission, more so when no violation of human rights had taken place. The court noted that the investigating officer had already recorded the children's statements and it would not be a problem to do so again. It also ruled that the State Human Rights Commission overstepped its authority regarding custody, as other laws cover custody matters. So now it has temporarily stayed the commission's order about custody and the children's appearance. Further, the court allowed the investigating officer to continue the investigation and the relatives to cooperate. It has said that the deceased mother's parents can take legal action for custody. The Madras High Court has granted bail to a temple activist, Rangarajan Narasimham, for allegedly making derogatory comments against a woman on social media. While granting interim bail, Justice V. Lakshmi Narayan asked him to delete all the offensive messages and refrain from making any abusive comments against women in any of the social media forums. Previously, let me tell you, in another case, the High Court had also ordered a 2-week social media detox for his distasteful comments against an industrialist. The court had also imposed a fine on him and commented that protectors of Sanatan Dharma should refrain from using such unsavory words. In the present case, Narasimham had made a social media cry stating that he had spent a lot of time and money appearing before the Supreme Court, and since the matters were not listed, it was a wasted trip. When the complainant in this case replied to this, Narasimham used derogatory words against her. Feeling aggrieved, she made a complaint under Bharatiya Nyaya Sanhita, the POSH Act and the IT Act, after which he was arrested. The next update is about a case revolving around a lease agreement signed in July 2021, where the petitioner in the case rented out his premises to the respondent, who is the tenant. He claimed that the tenant owed him money and tried to resolve it by emailing the respondent. The agreement had a clause, as generally is, stating that if there were any disputes, both parties must try to resolve them by arbitration. However, before starting arbitration, they were supposed to negotiate or discuss the issue amicably. The petitioner sent multiple emails to the tenant asking for payment. When no resolution happened, he formally sent a notice under Section 21 of the Arbitration and Conciliation Act of 1996 to begin the arbitration process. The tenant denied owing anything and argued that the notice was premature because the landlord had not attempted friendly negotiations before sending the notice, as was required by the agreement. Let me tell you, this Section 21 states that process of arbitration begins when one party notifies the other party in writing about their intention to start arbitration. The court said that the landlord did try to negotiate before the notice by sending multiple emails, so there was no need for further friendly discussions. The court also said that once the parties are firmly in disagreement, forcing them to negotiate again is pointless. Thus, it has allowed the arbitration to proceed and appointed an arbitrator as well. For more information on the cases discussed here, you can visit our website at www.livelaw.in. Your support means the world to us. So please do not forget to like, share and subscribe to our channel.